It was a bit of a gamble having this lecture tonight because we knew that there was going to be a tube strike. We had a lot of people double confirm that they were coming. And so we thought we would press on with it. So it's being recorded, so people that haven't made it can look at it later on. I don't know what is it. What does it go on, Alphege?
It's going to go on YouTube, and then there's also going to be on LinkedIn. There's going to be a link for that.
Right. Okay. But one of the main reasons we wanted to do it here was to show off our new building because it is magnificent. We call it new. It's obviously not that new, but it's new to us. And as you all know, in the legal profession, things that we describe as new are often quite old, because that new extension at the Old Bailey, I saw the other day, that actually opened 50 years ago. And we still call it the new part of the building. So this is new to us, and we hope to be here for a very, very long time. Now, we, Alphege and I, do a lot of work, and Chambers does a lot of work as well on gangs cases, because it seems to us that there are an awful lot of gangs cases being heard currently and have over the last few years. In 2016, there was a case called Admissibility that went to the Court of Appeal. We weren't in it, but it's quite an important case in the history of things, because counsel who didn't appear at the lower court but did in the Court of Appeal complained that evidence of gang and gang affiliation and membership was becoming more and more common, and the prosecution was applying more often than they used to adduce evidence of gang association. Lady Justice Hallett, who was the then Vice President of the Criminal Division and who herself was an experienced criminal practitioner, she observed in the judgment when counsel complained that there were so many applications now, she said, this may be explained by the simple fact that so many offences are now gang related. It does not indicate that trial judges are too indulgent of the Crown, she said. It is our experience that, as a general rule, trial judges are acutely conscious of the dangers of admitting gang affiliation evidence, and they take great care to ensure that bad character evidence is admitted through the appropriate gateway. Now, when you take that last bit together, when she said it's our experience as a general rule, trial judges are acutely conscious of the danger of admitting gang affiliation evidence and take great care to ensure that bad character is admitted through the appropriate gateway. One reading of that is that it's all bad character, that gang membership or gang affiliation is all bad character, and therefore an application under the 2003 Act is necessary. But actually, it isn't. Because now, following not only that case, but a succession of other cases, the Court of Appeal has repeatedly upheld the fact that if gang association or gang membership has to do with the facts of the case, then no separate application is necessary. And so that really is the starting point, I think, of any of the cases that we now do, to look at it and see whether or not it is a gang-related case. I think the expression, it has all the hallmarks or bears all the hallmarks of gang activity. And you know the sorts of cases, they're all quite obvious. But if it is to do with the facts of the case, then the next step, of course, and the big question, it is how much goes in. So firstly, do the Crown need it? And secondly, how much goes in? And what is gang membership? How do we define it? How does the court define it? What is a gang? What's gang activity? How does the prosecution prove that a particular defendant is associated with a particular gang? And from our perspective, what then should we do when we're defending? What should a jury be told? How much material are they presented with? And going back a little while, my experience certainly was that prosecutors were a little bit reluctant to go down the gangs route when prosecuting cases. They kind of tiptoed around it a little bit. And I did, because I prosecute cases and I defend them. And the reason I think really for the tiptoeing around is because adducing evidence of gang affiliation can sometimes be a bit of a risk, certainly more then than now. And I say then because we didn't have the authorities that we now have from the Court of Appeal telling us what is acceptable and what isn't. And so the prosecution was sometimes reluctant to risk what would otherwise be a safe conviction by adducing evidence of gang material if it wasn't necessary. I did one a few years ago where I prosecuted 5 young defendants, joint enterprise murder. What it was briefly is that 2 of them hijacked a car. They waited for a woman to get her BMW out of a private parking space in an underground garage. They held her at knife point, ripped the keys out of her hand, chucked her out of the car, and then drove off. They drove to a park in Hackney, I think it was, where their mates were waiting. All their mobile phones then got switched off. They all got in the car, and then there's CCTV and ANPR of the car driving down towards the Canning Town area. And we saw it on the CCTV driving into the Canning Town area, and there was a young boy there, young man, I think he's 16, 17, walking with a girl and one of his mates. And this car came around the corner, saw them, accelerated, ran straight into him. He flew up over the bonnet. The car crashed into a fence post, a brick like gate thing, and that started wobbling. The boy fell onto the ground, ran off. The car turned around, chased him up the road. He ran down an alleyway, and 5 of them got out of the car, chased him down the alleyway. Within 15 seconds, they'd stabbed him 11 times and all ran back to the car. Car, in the meantime, driver turned it around, picked them up the alleyway, drove away, and they crashed not long thereafter. Having crashed the car, they abandoned it. Eyewitnesses to the car crashing thought it was quite strange that these young black boys would be getting out of the car in the middle of the summer, all wearing white latex gloves. And they mentioned it to the police when the police arrived. So what the police then did is they got the CCTV, they started looking at the routes that these people had taken. And en route, they found latex gloves dumped in one case behind a lamppost, another case in a bin. They found a knife down a drain and linked it all up with DNA. And then followed the defendants until there was quite good CCTV and identified them. There was a long history of gang-related activity between Hackney and Canning Town. And we had a file like that thick of material and information. We didn't use it. We didn't use it because I suppose we could have done but chose not to. We didn't want to distract the jury with it. Always in this history of gang activity, there's always, well, was X involved, was Y involved? And because you sometimes can't prove a particular defendant was involved in an earlier incident, sometimes it loses its strength. And so we decided in that case to run it without mentioning the gang activity. And it worked. All 5 were convicted of murder. Question is, if I had the same case now, would I do it the same way? I don't know, is the answer. Possibly, possibly not. One of the points in that case was that one of the defendants had himself been stabbed on a previous occasion 7 times. And he was taken to hospital. He refused to cooperate with the police, wouldn't say who'd done it or why they'd done it. Then on a subsequent occasion, he was shot at and again said to the police that he wasn't prepared to speak about it at all. And so we were faced with a situation where defense counsel wanted to make an application before his client gave evidence, having treated as someone of good character on the basis that he was a victim. Anyway, we opposed that because we said he was obviously a victim because he's a gang member, but we hadn't gone down the gang route. So it all got sort of rather complicated. But anyway, it all resolved itself and he wasn't treated as somebody of good character. A warning shot was fired across his bowels. But there's a more recent case now called Abdi. And Abdi was a Birmingham case, I think, where the defendant, I think, is in a Coventry gang. He had been stabbed on 2 separate occasions, and he had refused to cooperate. And the Court of Appeal said, well, that had all the hallmarks of him being a gang member. There was other information as well, other material. But the Court of Appeal said, well, that doesn't make him a victim effectively, that makes him a gang member. So if we'd known the Abdi judgment then at the time I was doing this other case, I suspect we would have used it and said, well, it does actually go to the issue of whether someone is a gang member. So that was the position that we used to be in. Also, and I think Alphege's experience, probably the same in mine, and Chris as well, maybe, is that when the defense back not that long ago objected to Gang's evidence, they did it because they said it's so dangerous, because juries automatically think because you're a gang member, you must therefore be guilty. And there was 1 or 2 cases I heard of at the Bailey where actually the judges wouldn't allow the word gang to be used. They called them groups of people as opposed to a gang. Well, I'm not sure really how that helped, to be honest, because I would be amazed, frankly, if any member of a jury sitting at the Old Bailey would not reach their own conclusion that the people were all part of a gang rather than just a group of young boys who happen to know each other or be part of the same group. But as I say, it did happen in the past where judges at the Bailey said, well, using the gang word is too prejudicial and it can't be used. But as I say, that now seems to have changed quite dramatically, and there has been a sea change, been a shift from that reluctance by the prosecution to adduce this evidence. And there's certainly, as Lady Justice Hallett said, there is not an indulgence by judges. There's an acceptance of realization that cases are gang affiliated. And you know the types, they're obvious. They're obvious if it's a gang related attack. It might be revenge. What we do know is that the police work really, really hard on these cases. And I know it from being on that side of the court as well as on the defense side. So I spend a lot of time with police officers who investigate these murders, and they know so much about the local gangs, about the disputes, about the rivalries. They have access to all the intelligence materials, so they know if something is a retaliation attack. They know everything. A little bit like, I suppose, the traffic police officers. A little bit like the traffic police officers. They know obviously everything about the road traffic law, and they're very, very keen to tell everybody about it. Those that investigate car accidents as well, you know what they're like with their measurements and their dimensions and diameters of tyres and skid marks and that sort of thing. And the police that are involved in investigating the gangs links to cases, they are on top of their subject and they know it intimately. And so you will get cases where on the face of it, there doesn't appear to be much of a motive. But then you'll get the evidence from the Crown Prosecution Service that makes it absolutely clear that this was a revenge or retaliatory attack because of various previous incidents that had taken place in that area between those gangs that are involved in the murder and of course, the deceased. And so when you're faced with that, you know that it has all the hallmarks of gang violence. You'll know because there's a ride out. You'll know because there are drill videos. You'll know because there are machetes involved. There are zombie knives involved. And you will know from your clients that this was a gang attack. And it therefore goes to motive. If it goes to motive, it has to do with the facts of the case. And motive, of course, can also assist on identification, because the police have done their work, they know who's involved in which gang. And they can then say, well, he is one of the leaders of X gang, and they've been in rivalry with them, etc., etc. They've been in rivalry with this other gang, and that was the motive for the attack. And therefore, I know that he's been identified as being involved in this. So it's his gang affiliation that goes to motive, it goes to intention, it goes to identification. And those are section 98 to do with the facts of the case. So you don't need to go anywhere near the bad character provisions. The prosecution don't need to do it. The judge then has to decide whether he or she is approaching the case on that basis and whether the admission of the evidence is unfair. But let's say that it is to do with the facts of the case. How then does the prosecution prove it? You then move to the bad character provisions. Whilst everything isn't bad character, some of it is. For example, a drill video. Drill video isn't necessarily bad character. It may, as we often say when we're defending, it's just these boys who are being a little bit leery and putting things on YouTube and putting things on social media to try and wind up the opposition gang. Look at us, aren't we great? Aren't we bigger than you? Our zombie knives are bigger than your zombie knives, and that sort of thing. That's not necessarily bad character. And that does actually go as well to identification of individuals and motive. But there are some things that obviously are bad character. And those things that obviously are bad character, previous convictions, previous stops by the police. Quite often we have situations where local police officers will challenge a young defendant and he'll run off and he'll chuck away a zombie knife en route. Quite often not prosecuted because the police just don't bother, frankly, prosecuting things like that, particularly when defendants are young and they know not much is going to happen to them. Or they're caught in a gang drug dealing area with drugs and a lot of money. Again, they don't tend to prosecute some of them because they know that it's not much is going to happen to them. So there are some things like that that will always appear in the documentation. And that is actually bad character. Sometimes the gangs officers have social services records and they have people talking about which gang they're in, and they try and put them on, I can't remember the exact phrase, but when they try and get them away from gangs and get them to move away from gangs. Diversion, thank you very much. So get gangs diversion. So they try and get the young people away from that. And that, as I say, can be regarded as bad character. So sometimes the prosecution have to make applications under the 2003 Act. Sometimes they don't. Again, I suppose going back to things that are obvious in gangs cases and why things may be automatically admissible, you try and think of a case or cases that are slightly away from the gang scenario. If you get a woman, for example, who kills her husband, and she's saying, well, it was a terrible accident. He fell down the stairs and hit his head 3 times as he was bouncing down the stairs. And the police do searches on her computer, and they find out, in fact, that she's recently checked life insurance and she's taken out extra life insurance. And they check her computer and they find out she's got a lover. And it's quite obvious that the motive for her would be to bump him off. It's, I think, probably inconceivable that anybody would say that that is not to do with the facts of the case and isn't automatically admissible, subject, of course, the judge saying it is admissible. I suppose if you go into a rape of a child, if someone's accused of that, and they've got a whole load of porn on their computers dealing with, or on the computer dealing with the rape of children or something, of course that's to do with the facts of the case. I suppose there's an overlap of bad character as well, but it's to do with the facts of the case. And so that's why more and more and more times now, when prosecutors are looking at it, they're just saying, well, this is all to do with the facts of the case. And if you have a group of defendants who have appeared on drill videos with zombie knives, machetes, making gun signs towards a sign that they might be making with their hand of the opposition, and one of the opposition gets stabbed, it's quite obvious. I think that is the sort of material that would be admissible. And so, with those different strands of evidence, firstly, is it admissible, Section 98? Secondly, is it bad character? And see if there is a difference and a distinction between bad character and just simply to do with the facts of the case. There used to be objection taken as well to police officers giving evidence about their experience of a particular gang or gang-related activity. It goes back to what I was saying just a few moments ago, that the police do so much work and they know so much about these people that are on trial. And this is where Alphege comes in, because I know that he's going to be dealing with things like definitions of gangs and what the police know and this sort of thing. And it's important, and it's actually very important, because evidence used to be objected to on the basis that the police officers who were going to give the evidence weren't experts, and they were giving opinion evidence. And of course, if you're a non-expert, you can't give your opinion. And more frequently, police officers were being asked to give their opinion. Sometimes judges were saying, no, you can't because you're not an expert. So what happened, in fact, is that the Crown Prosecution Service instructed one of the senior Treasury counsel to, I'm not sure whether he lectured the police or whether he devised something, a statement form for them, setting out what it was that they needed to say and needed to show in order to become experts and therefore give opinion evidence. And they, the police, having done that, now when you get a gangs case, you will see probably a statement that goes to 20, 30 pages sometimes of the police officer, who's a local gangs officer, setting out all of his knowledge, setting out his expertise. And there's no way, I'm afraid, that we can generally get around that, because police are now regularly regarded as experts. Started the Court of Appeal started to say, well, yes, an officer can give evidence, but again, some judges were reluctant to permit them to do it. But now it is quite clear, the way they present their statements and they present their evidence, that they are experts. And Alphege is going to tell us a little bit more about that.
Good evening, everyone. Thanks for coming. Thank you, Anne. Right, okay. My name's Alphege Bell. I'm one of the junior practitioners here at Mountford, and my own personal experience in recent years has been a lot of gang work or bailey work or multi-handed murders. But what I'd like to do, if I may, is to really just sort of look at where we are now in terms of how these cases are managed and how they're prosecuted, and what the checklist is in respect of the police officer's statement. And just before I get to that, I just want to lay the ground in terms of the legal cases, or the legal case in particular, which is Myers, about what those ingredients are in terms of the requirements of the police statement, and why it's important, and why it's an important starting point in terms of you doing the preparation for a gang case. So just before I deal with the officer's statement, the case, if you look at all the cases on gang evidence and gang admissibility, most of them are pro-prosecution. And without saying everything that Anne's already said, essentially you almost have to work on the basis that it's admissible in one form or another. whether it has to do with the offence 98, whether it's 101D, etc. But what you've got to do is you've got to also think about what the legal sort of progression has been in respect to those requirements. And the key case is really Myers. So it's Myers and the Crouch. So it's a Privy Council case, which was in 2015, and the reference is UKPC 40 if you want to go on the Supreme Court website. But what's important about that case is you've got the Supreme Court, so not the Court of Appeal, which we know isn't necessarily appellant friendly, but you've got the Supreme Court looking at the principles around the admissibility of gang evidence. And there aren't many instances in the authorities where you've got that level of judicial scrutiny in respect of this issue. And the lead judgment that was written in respect of that was written by Lord Hughes, who I'm sure you all know very well. But if you don't, what's important about his experience and his background is that he was himself a criminal practitioner. And for many years in Birmingham, he sat as a recorder at the Midland Circuit. And so although he was dealing with a case which was the Privy Council, and there's a little rider here, a little wrinkle about the fact that, of course, the Privy Council was dealing with cases outside of the UK, so it's not necessarily refracted through the prism of the Criminal Justice Act 2003, but it was adopted later on in other cases. But I just want to go back to that case because it's really important. It was dealing with conjoined appeals in Bermuda. So it was dealing with a host of criminal cases around gang evidence. And what the court wanted to do was establish some core principles about what's really required by the court before the court can then go on to consider how this information in respect of gangs might be presented by a jury. And it was such an important case in terms of that issue and what it did, that there was a Judicial College e-letter, which, I mean, I'm not breaking any confidences in telling you that it was sent around to all the judges. But what I want to do is to just work through some of those core principles that were sent to the judiciary in 2015, following Myers and following that case. And what they effectively said to the judiciary is that evidence of a motive shared by a gang member may be relevant and admissible without the motive being harboured uniquely by one defendant. It's just another way of saying that the context of tit-for-tat violence may be relevant in any given trial, irrespective of whether or not the defendant was himself part of the history, right? But the short point of that, and it's really important, is that that's effectively a judicial position of accepting the need for the court to at least consider the history, almost irrespective of the CJA provisions, almost irrespective of almost relevance, if you like. Is there a background that shows tit for tat? And if there is, whether or not the defendant participated, the court should at least look at it to see if there's some context. Now, from that, what the court is essentially suggesting, or what the e-college letter is essentially suggesting, is that where the court's going to choose to consider that background, there is a requirement that an officer who purports to be an expert must produce a detailed statement which qualifies him as an expert and then sets out what his experience is, what his knowledge is in relation to any particular relevant gang or grouping, what the history of that gang is, any evidence as to any episodes that he knows about, and state where he got that information from. So if you like, some of you might be familiar with the issue in terms of the gang matrix and the issues, the criticism about that from Amnesty, about not necessarily being reliable and so on, because it was effectively relying on oblique intelligence, which wasn't then disclosed to the defence. So what this is effectively doing is almost cutting that off and saying, right, if you are a gangs expert officer, what you need to do is to show disclosable information in respect of the history of tit for tat, whether it's Chris, whether it's previous stops, whether it's previous arrests, whether it's previous convictions, whether it's YouTube, etc. So what's important then is that officer constructing that statement needs to show transparency in relation to that information, which is an important safeguard and provision. But in addition, of course, he's also got to go through the hoops of, as it were, stating that he's an expert and he understands his duties to the court, duties to be objective, the duty to consider fresh or other evidence and matters of that sort. Now, the reason I've set that out in that way for you is because whenever you pick up a case that has the flavour or possibility of it being a gangs case, you must check to ensure that whatever statements are being relied on to form the basis of a potential application to adduce bad character or gang evidence generally, that it complies with that. Because if it doesn't comply with it, then you're entitled to take issue with it, to object at that point to its use or its admissibility. So the case of Myers in particular is, I think, possibly the most useful in terms of how you might seek to challenge the admissibility of gang evidence at that early point or that early stage. But if we go past that point, and if we just work on the basis that whether under Section 98 or whether under 101D or any other provision of the Criminal Justice Act 2003, if we just work on the basis that the court is minded in principle to allow some evidence in respect of gang membership or gang affiliation, then the next stage in terms of defending those cases is to look at what it is that you can do to control and manage that evidence. Now, I'm not ignoring, Section 78 or any other residual discretion to challenge admissibility. I just want to focus now really on the trial aspect. And you're faced with video, or you're faced with phones, or you're faced with pictures, and you're considering what you do about that. And very often, I think a lot of counsel or defense practitioners, once they sort of understand the judge has ruled against them, almost don't show enough vigor about interrogating the width of the admissibility of the evidence. So if the judge has ruled in principle some of this evidence is relevant or admissible, well, what's the presentational end that you're working towards? So, for example, will a still do better than a video? If we're just talking about someone wearing particular gang colours or whatever it is, we don't necessarily need the misogynist language and all the other things that generally come with the sound clip. And just to give some thought to just, a picture or a very short excerpt or video without sound. I mean, these may all sound very obvious and elementary, but you'd be surprised how often in trials people overlook that level of scrutiny and presentation and trial management. But more importantly than that, what I would also say that very often in these cases, it's a multi-handed situation. There's potential for either explicit cutthroat or accidental cutthroat. And so you get into a situation where, if you like, you're dealing with the prosecution or you're trying to manage a situation with them, you're dealing with the judge in terms of whatever submissions you're making to the judge, but then you're also having to deal with your co-defendants. It may be somebody wants to go hard on gang evidence, but you don't. It may be, for example, you might be representing a secondary party who's not the principal, who's not the stabber, or not the shooter. And they may want to run a narrative which is that they're a victim. And that they're, I say a victim, what I really mean is that they're a sort of peripheral figure, and that whatever everybody else is up to, they're not really signed up to it. And so when you've got those crosswinds and you've got those tensions as between the parties, again, it's an area that requires very careful management and scrutiny to ensure that you are doing the best to advance your client's case. And sometimes practitioners get a little bit lost in the distinction between what's sufficient for their case and perhaps sometimes just overspilling and using more of the material than they need, or sometimes being restricted. The simple point is each case, each defendant turns on its own facts. And once you've dealt with the headline issues of admissibility, and once you've dealt with the headline issue of what the Crown's attitude is, you've got to really drill down in a very particular and focused way to ensure that how you manage that material and its admissibility and its scope and its presentation is truly focused on what it is that you're trying to achieve for your client. The other point that I would make about when you're in a sort of multi-handed case or multi-handed situation is that if at all possible, if you can work as a team in respect of how you attack the Crown's position in relation to the admissibility of this evidence, that is always a bonus to the defence team. And sometimes what happens in these cases, and it's something that perhaps happens too often, is that people work in their silos, and we're almost used to, if you like, whether it's individual practitioners or just simply representing one defendant, we think solely or wholly about our own case. And of course, I'm not suggesting that anyone should ignore the exposure or in any way give away an advantage to in respect to their client. But no one's got a monopoly necessarily on the best strategy. And the better that you can work together as a team, collectively against the Crown, the better it is potentially for everyone. And I mean, it may seem almost a basic observation, but you'd be surprised that in how many cases there is a lack of cooperation, a lack of joined up defence strategies, whether it's egos, whether it's your habit of work, and it's often to the detriment collectively of all of the defendants. And very often it may be that someone's seen something in the news that you haven't seen, or they've got a particular take on a particular point. I think sometimes we have to be humble as practitioners and say, well, we're not across all of the issues. And then particularly with this sort of unwieldy evidence as it is, the more minds that are joined up, the better that it is. So I make those observations really about management and strategy, because I think they're just often lost for whatever reason in the context of gang case, and people always go, you know, only me, there can only be one who's got all the ideas. The last issue that I'd raise in relation to trial management is routes to verdict. Routes to verdicts are a new phenomenon, and there isn't really much learning or jurisprudence on how you draft it, on what the core elements are, and what you're doing, into what you're trying to achieve from a defence point of view. Obviously, notionally, we're trying to give the jury some guidance about how they reach their routes to verdict. But it's actually a very fertile and critical ground in terms of trying to win these cases, that a lot of care and a lot of attention is paid as to how the jury is directed in terms of routes to verdict. But also, for example, if you can think about whether factually a knife is used or not, or intention in relation to a knife or a weapon, just working together in the context of the history of the gang evidence around how you draft a very effective route to verdict collectively is another source where people can cooperate. What we're sort of dealing with in the end, really, obviously, is gangs and gang evidence. But it's also just worth pausing for a moment to think about what is a gang? And that's not an existential philosophical question, because the definitions are varied. And actually, if you ask someone what is a gang, people would often come back with a number of definitions. So I just want to cover a couple of definitions, which I hope will make you think differently about how gangs are defined and how they're applied in criminal cases. So the Oxford or the English Collins Dictionary even defines a gang as a group of people, especially young people, who go around together and often deliberately cause trouble. Is that a sufficient definition? But apparently that's in the dictionary. The reason I say that is because it makes you think, what does a jury think when they hear the word gang? And that captures some of those elements. Another definition is Section 51, the Serious Crime Act, 2015, which I'm sure some of you are now very familiar with in terms of people being charged with being members of organised crime gangs and all of that. That defines gangs as consisting of at least 3 people, has one or more characteristics that enable its members to be identified by others as a group. And what's interesting about that definition is it's broad. It's massively broad and wide. And it's drafted in that way for the purposes of gang injunctions. But the Crown Prosecution Service, they say urban street gangs and many other gangs may evolve into organised crime groups. Urban street gangs tend to be less organised than OCGs and more concerned with perpetuating a threat of violence or harm across a geographical area related to the gang's main activities. These types of gangs can be involved in varied forms of serious criminality that can have a significant impact on local communities. So that's the CPS definition of a gang. And the Metropolitan Police Service defined a gang as a relatively durable, predominantly street-based group of young people who see themselves and are seen by others as a discernible group and engage in a range of criminal activity and violence. They may also have any or all of the following features: identifying with a lay claim over territory, have some form of identifying structure or feature, are in conflict with others or similar gangs. And then the last definition that seems to be useful in this context is that offered by the Centre of Social Justice. I'm sure for bedside reading, if you want to read, it's called Dying to Belong, which was written in 2009. They define a gang as defined as a relatively durable, predominantly street-based group of young people who see themselves and are seen by others as a discernible group, engage in criminal activity and violence, lay claim over territory, not necessarily geographical, but include an illegal economy territory, have some form of identifying structural feature, and are in conflict with other or similar gangs. Now, you'll see there are many different definitions, how they borrow from each other, but there isn't a uniform or clear concept. Why do I take the time to set that out? Because when a jury hear the word gang, they could understand any one of those. And so there is inherently an incendiary prejudice in the word gang. Sometimes perhaps you can just front up to it and use it to your advantage, but it's important to understand that that meaning has such a variety, such a prejudice, which is why it requires very significant care about how you handle any information in a trial that uses or has any reference to the word gang. I see the time. I think I've covered the core points that I wanted to make. I don't know if anybody's got any questions or if we rush straight to one. No, you're being very kind, aren't you?
Can I just add a couple of things to what Alphege just said in terms of presentation? What we must never do, ever, is let the police officer give evidence. Never, ever, ever let the gangs officer go into the witness box to give evidence, because he will just want to tell you absolutely everything that he knows, like the traffic officer, for example. So in terms of presentation, make sure there are agreed facts, and they can be as anodyne as possible. So, for example, D1, whatever his name may be, accepts that he was affiliated to, I don't know, the SC gang, for example, because then your client can say what he likes about it, and generally does. Well, that was just me dealing drugs in that particular area, piggybacking on to the definition of committing crime in the area. I'm not into the violent side of things, but I'm into the drug dealing only. So the judges and prosecutors will always be keen, I think, to draft agreed facts. And as Alphege says, make sure that you are on it and make sure that you have the agreed facts that you want in the case as well. And you can very much use it to your advantage. If you want to have a look at the authorities, some that I've referred to and some that Alphege has referred to as well, I did a thing on the Chamber's website a little while ago in 2021 called One of the Gang. It's quite difficult to find, but it's if you go onto our Chamber's website and then you go onto my little photograph, and then
because we all want to look at them.
We all want to look at them, but that's the only way to find it. And then you go on it, and then you go on to not publications or topics. I can't remember what it was. Yeah. It's in there, and that has actually the list of authorities in it. The ones that we haven't put in there because they're a little while ago are more recent ones. Case of Heslop and others, which I prosecuted. That went to the Court of Appeal, and the one of Abdi, which I mentioned before. Abdi is useful because it does set out the core principles. And the core principles, just to repeat and to finish off. Firstly, that gang evidence is not admissible unless it's relevant to an issue in the case. Even if it's relevant, it'll be excluded if its prejudicial effect outweighs its probative value. Evidence of motive and intention for an offence will always be relevant. Gang evidence in relation to an individual may be relevant where identity is in issue. Gang evidence could be admissible as evidence of the alleged facts, section 98 or 101D, or both. Whichever route is taken, the judge is required to consider whether admitting the evidence would have such an adverse effect on the fairness of the proceedings that it should not be admitted. That gang evidence can be given by suitably qualified police officers who are regarded as experts, and once admitted, as I say, sort out agreed facts. As Alphege says, images are far better for your client than the full from the full video. And there are oftentimes, I had it very recently in a case where we wanted to make a virtue out of the gang evidence. I defended someone with Joe. We were defending someone who was part of a gang from Croydon. They'd moved to the Streatham area because one had been released from custody, and the probation service rather foolishly put him in another gang area. And these boys went out to get some chicken, and they all went out with their zombies and their machetes and everything, just in case they bumped into people from the Streatham gang. They did, because two boys from the Streatham gang were on their way in an Uber to Brixton. They were in a gang called the Get It Done, the GIDs, because they were out for retaliation of someone who stabbed their friend, I think, a couple of days before. But they saw our clients in Streatham, stopped the Uber, got out and attacked them with their machetes and knives that they had with them. So a street fight took place, all on CCTV, 4 of our side, 2 of their side. We chased them away down the road, and my client stabbed one of them through the heart and killed him. We wanted to adduce all of the evidence of gangs in relation to the dead boy and his friend. You may be surprised the counsel who was representing the prosecution objected to it, didn't like it, because it was so overwhelmingly important for us. We got agreed facts in. We didn't use everything that we had, but the judge allowed us to use some of it, and it worked out well for our client who was acquitted. And there's one that I've just finished, in fact, where we have one of these really long statements from the police. Part of it was read, because that's the other way to deal with it, not just agreed facts, but allow the prosecutor to read some aspects of it. And in this one, I had pages and pages and pages of this person's a member of a gang, this person's a member of a gang. And then it got to my client, and they said, we've looked at all the indices, we've looked at everything we've got. He does not appear to be a member of a gang. We've got nothing to suggest he is. There's no nickname for him, nothing at all. So that's fine. But another bit in the statement that the judge actually allowed the prosecution to read was this: but that doesn't necessarily mean say he isn't a gang member. It's just we haven't caught him yet, effectively, was what they said. And they based their case on the fact that when his home was searched, they found under his bed in a box a bandana that was red, that was the same color as a bandana that two of the co-defendants had been wearing on previous occasions when they were arrested. So he said that makes our client, no matter what the police say, potentially a gang member. But all is not lost, because it's a little bit like, I'm afraid, the bad character provisions, in that when we started 20 years ago with the bad character provisions, people always thought, well, that's it. Once the jury knows my client's got form, then they're going to be convicted. It doesn't work like that, happily, in gangs cases. In the Heslop case, this is what the judge said, and it was approved by the Court of Appeal. The evidence of gangs is before you as part of the facts of the case, and because it tends to prove a motive for this attack and the common purpose of those said to be involved. The prosecution say that given the evidence of group planning, specific geographical movement of the moped in question that carried the shooters to the scene, the fact that the two victims were engaged in a cannabis deal and the use of a firearm all suggest this attack had an objective of gang rivalry and hostility. You should approach this evidence fairly. Gang association does not automatically mean the defendant is guilty of the offences charged, but you may use the information as part of the body of circumstances which may tend to show a common purpose between those who you find had such an association and so a motive for the attack. So judges do give warnings to juries. Don't overreact just because this is a gangs case. Think about it fairly and sensibly. And you know what my experience is that they do, in the same way as bad character, in the same way as someone who makes no comment in interview or puts in two contrary defense statements. Juries see through that and see behind it. So don't worry. Don't panic about it if your gang evidence goes in. Be in control of it, and I think to some extent embrace it. In the case that Joe and I did, the defendant said, well, of course we were walking around Streatham with zombie knives and machetes hidden down our trousers because we're in a rival gang area. It's not safe for us. Of course we carry weapons with us all the time. Every time I go out, I carry a weapon. I don't travel on public transport because I'm frightened that I'll bump into rival gang members. That's why they get Ubers and taxis everywhere, because it's safer for them. And so sometimes it can actually be turned very much to your advantage. So as I say, it's not all one way. It does help the defence. And so what I hope, and what Alphege hopes as well from this, is that when you see your clients, you can perhaps give them realistic and sensible advice that it's going in, but we can control it and not to worry. All right, thank you very much indeed.